Please be seated. Good afternoon, ladies and gentlemen. Welcome to the Fifth Circuit Court of Appeals. We have one case to be submitted this afternoon on oral argument, Ramey versus Lumpkin. Ms. Burgin.
Good afternoon, and may it please the court. My name is Alisha Burgin, and I represent petitioner and appellant Kershawn Elijah Ramey. Mr. Ramey was convicted of capital murder and sentenced to death following a trial infected with constitutional error. Two of those many errors are before this court today. First, Mr. Ramey, a black man, was tried by a jury with no black people. This was by design. The state systematically excluded black people from the jury by, one, questioning black veneer members markedly differently than whites to elicit cause. Two, using a jury shuffle when black veneer members were concentrated in the front of the second panel. And three, when racialized questions, including whether she was transferred at work because she's black, and a confusing interrogation regarding the burdens of proof did not elicit cause, the state exercised a peremptory strike against Cheryl Steedham Scott. Despite this clear and convincing evidence that race was a paramount consideration for the state in jury selection, all Texas courts have found Ms. Scott's strike was not racially motivated. The state court's reliance on race-neutral justifications that were not offered at trial and failure to consider the full context of the state's actions during jury selection resulted in a decision that unreasonably applied clearly established federal law and was based on an unreasonable determination of the facts.
Were some of the jurors struck for cause?
Were some of which jurors?
Some of the potential jurors struck for cause?
All but one of the black veneer members were struck for cause.
Now, some were Mr. Ramey's relatives, is that right?
There were 9 black veneer members in total in a panel of, I believe it was 153. My math may be off. 2 were related to Ramey and were struck for cause. The other 6 were struck for cause following disparate questioning that elicited cause.
Part of the challenge, again, and you correctly framed it, is there has to be clearly established law. And one of the wrinkles, often it gets difficult when there are unusual fact patterns, and here counsel doesn't object for a long time. So clearly, when you look at the transcript, everyone's caught off guard. So I guess, is it correct that what you've got to establish is that there's clearly established law that when a Batson objection is made, and the TCCA concluded it was timely, but the counsel does not ask for a comparative analysis, is it your position that clearly established law is that trial judges themselves have to do that third step, comparative analysis? Is that essential to your argument?
It is not my position, per se, that the trial court has to do just the comparative analysis, but rather that clearly established federal law requires the trial court, as part of Batson's third step, to look at all facts and circumstances.
Right. So here the issue is, did the judge do the facts and circumstances? And the judge on the transcript's racking his brain and asked the government, I'm trying to remember, I think she was asked and had responses about the death penalty that was different. But for you to prevail, you need to be able to draw the comparative analysis to Ms. Laza. Was that the name of the woman who may have had more doubts about the death penalty?
Yes.
So, but doesn't that require you to have a case that says a trial judge, even when it's not asked to compare jurors that were left on the jury, has to do that under the fact and circumstance formula set up by Miller-El?
Well, I do have a case that says that, and that is actually Miller-El. And Miller-El, the trial court and the Texas Criminal Court of Appeals were not presented with a comparative analysis. And honestly, I don't think it was raised until federal habeas. And yet the Supreme Court was able to find that there was a violation of clearance.
But we wrestled with that in Chamberlain, didn't we? You're familiar with the Chamberlain en banc decision?
Yes.
How isn't it the conclusion of our en banc court that the law doesn't require trial judges to sort of discern that you wanted to compare to this person who did sit? That's my difficulty with this issue.
So it's our position that the law requires the complete analysis, and comparative analysis is just one part of it. there are other facts and circumstances that were available to the trial court that suggest that there were racial motivations behind the strike. And one example of that is the jury shuffle, which occurred per Texas procedure without the jurors having filled out questionnaires and without the attorneys knowing very much about the jurors at all besides their visual appearance. Yet, there was a shuffle when 4 of the 6 black veneer members were among the first 10 people in the panel. And the reason that the state offered for that shuffle was implausible in and of itself. The prosecutor stated, I've got people looking into this and I've got a list and people have told me the good state's jurors would be in the back. But the way that the jury shuffle procedure works, it is taken from a random century pool. Sorry, got a little flustered there. The way that the jury selection works in Texas and in this particular county is there's a random pool that's qualified, and in this case by a different judge, and then they're dispersed to the courtroom. And moments later, the jury shuffle was requested, so that's implausible.
Let me see if I understand that. You are saying I guess the major premise is unreasonable application of Batson and Miller L.
Yes.
And so that gets you over the AEDPA bar. And what you're saying is that part of the unreasonable application was the failure of the trial judge to consider all of the facts and circumstances, and that includes the jury shuffle, right?
Yes.
Okay, so at the time that this was happening, was it clearly established law that a jury shuffle was part of a Batson analysis that a trial court would have to do? Or whether was it the reverse? In other words, was it established that in fact a jury shuffle is really not part of the Batson analysis? Is there a distinction there? Because I noticed in the state habeas that separate claims were made, one with respect to a jury shuffle, one with respect to Batson.
Yes.
And now we seem to be talking about them together.
Yes. So Miller L. was decided in 2005, which was 2 years before Mr. Ramey's trial. And Miller L. instructs that a jury shuffle is an indication of, potentially an indication of a racial motivation. So I would posit that clearly established federal law did exist at the time there. And as to the 2 claims that were raised by Ramey's trial counsel, which I still shake my head at their work, one was that the jury shuffle itself was a Batson violation, which is not the law.
Yeah, that's not right.
And the second was about the strike of Ms. Cheryl Student-Scott. However, because that first incorrect Batson challenge was raised, the facts of the jury shuffle were placed before the court.
Okay, all right, well, that's helpful. But I guess I'm still hung up where I think maybe Judge Higginson at least suggests he may be, which is we considered what an unreasonable application of Miller L. may or may not be in Chamberlain. That was 2018. I think it was 2018. It was fairly recently.
2019.
2019. It was before I was on the court because I don't remember that case. And we said over a pretty strenuous dissent that it is not an unreasonable application of Miller L. for a trial court when not presented with the comparative analysis to then go ahead and sua sponte do it, that wasn't a built-in requirement in Miller L.
Yes.
And it does seem to me that your arguments are sort of in tension with Chamberlain.
Perhaps, and to maintain my credibility, I will concede that part of my argument is in tension with Chamber. But the comparative analysis, again, is only part of the combination of the facts and circumstances that strongly support the inference that race was a motivation here.
Okay.
Other parts of it include the disparate questioning that this court highlighted in its published opinion granting certificate of appealability, which shows that with respect to the burden of proof, black veneer members were interrogated and given confusing questions about the burdens of proof, 2 burdens of proof, and white veneer members and seated jurors actually received an education about the various burdens of proof, and it were explained that they only had to answer 2 simple questions to fulfill their jury service. And another example of the disparate questioning is with respect to religion. Carolyn McGrew, a black veneer member who happens to be a wife of a Baptist deacon, was told that because of that role, she was unlikely to impose the death penalty, whereas Craig Ullman and Mr. Thomas Ellis and I think it's Rudolph Estrada were all reassured that their religious beliefs would not interfere with their ability to impose the death penalty. And that's really striking here because all three of those men are not Black. And Mr. Ellis himself was also a Baptist, and Mr. Ullman, an elder in the Lutheran Church. And other evidence of racial motivations that was in front of the state court include the very questioning of Cheryl Steedham Scott. She was asked if she thought O.J. was guilty and Michael Jackson was guilty, and both those cases are entirely irrelevant to the crime with which Mr. Ramey was accused. She was asked when she testified that she had been transferred at work 4 times, she was asked incredulously if she thought that happened because she was Black. Also, O.J. was repeatedly, the O.J. Simpson case was repeatedly referred to throughout jury selection by the state. The state repeatedly told jurors that they would not have to be sequestered for a year like the O.J. Simpson jurors were. And a decade after that case, there really didn't make sense to mention that case other than for racial reasons, and it was a particularly racially polarizing case.
Already in Chamberlain, there was circuit discussion of this sort of core problem, even as to racially disparate questioning. The core problem being the defense attorney at the time didn't ask the district court to do it. So the logic of your rule is the facts and circumstances that should be done, where there's a third prong Batson objection, wasn't. But it has to be that the district court had to do it sua sponte. Do you have any case that says that that's current law?
The district court had
The trial court, when there's a Batson objection, we think the reason you've been given is pretext, it's really for race. But then the lawyer doesn't say to the trial judge, and here's why we think it's pretext. Either someone who's sitting wasn't asked those questions, or this lady who's Black was asked racially probing questions to trip her up. So what's the best even circuit, and of course we're looking for Supreme Court law, that says there's Batson error when a trial judge doesn't do that work for the defense attorney?
I'm unaware of any precedent that says specifically that the trial judge has to do that work for the defense attorney. However, Batson and Millerell itself describe the third step of
They do.
as requiring the judge to consider these and make a determination as to whether the race-neutral reason offered was pretext.
Slightly related to this, and you clearly have studied it well enough, so this is not a gotcha question, but you remember the district court's opinion. It's extensive. Do you have a specific recollection of if you have it there in front of you, you could peek at it. Footnote 12 is about the Batson moment with Steedham Scott. Footnote 12, I think it's worth it, if you don't mind finding it. I didn't understand the last sentence of the footnote. And what I think if you've got it there, the district court says that your client is not pressing the argument that the district court failed as to its Batson inquiry. If you can't find it, you could look at it.
I don't think I have it with me.
Okay, that's all right.
On my computer.
It's somewhat inexplicable. Maybe when you sit down, if you have it, you can.
Take a look at footnote 12.
Footnote 12 has been confusing to me. So you're right. You're the answer to racially disparate questioning and comparative juror analysis, both of which absolutely in the law can suggest pretext. But when a defense attorney doesn't ask a trial court to do it, my problem is, what's the law? This Batson happened so quickly, it's spur of the moment. Are we really saying it's clearly established law that the trial court's got to turn around and start asking the government all these questions when the defense attorney hasn't?
The trial court entertained the challenge and asked for him to provide.
Well, the trial court said, gee, that was 21 days ago. I'm trying to remember. Government, what was it? Didn't she have problems with the death penalty? That all looks very authentic. So the trial court's struggling too. I think someone said they don't even have their notes.
Neither had their notes, which is interesting given that the jury had not been impaneled yet.
Yeah.
So we were still in voir dire, and under Texas law, a Batson challenge may be raised until the jury is sworn. However, the state still managed to offer some reasons and offer to resurrect his notes.
But
and
the
the trial
reason
court
it gave
declined.
is a correct reason. There's no doubt in my mind that Stedham Scott had difficulties with the death penalty. The question really is, did Miss Laza have even more difficulties? So it really required someone to say, but maybe this bleeds into your ineffectiveness. We granted COA on 2 points.
My ineffectiveness focused on investigation, but this is one of the many ways that Mr. Ramey's trial counsel was ineffective, unfortunately.
Why don't you turn to whatever your best argument is on that second?
On the ineffectiveness?
Yeah.
Well, my argument on ineffectiveness would focus on prejudice here. And as you've seen from our briefing, we have provided ample evidence that has been uncovered by federal habeas counsel's investigation that was not uncovered by trial counsel. Trial counsel instead opted to rely on the state's open file instead of doing its own investigation. And that also goes to mitigation in the penalty phase, which is not before this court, but is also troubling evidence of counsel's ineffectiveness. We've found a number of significant evidence showing that, give me a moment, that had trial counsel conducted the investigation and been able to effectively cross-examine the state's witnesses in a case where there was no physical evidence against Mr. Ramey, it would have undermined the credibility of several of those witnesses and the integrity of the state's case, and significantly of Mr. Norman, the accomplice, or the alleged accomplice, who was rehabilitated by the state as an explanation for his inconsistent statements and lies by presenting a narrative through his testimony that he was now searching for the truth. He knew he had nothing to lose, and so he just wanted to be honest and was just increasingly becoming a good person, whereas the facts actually revealed that he did have motives to lie still and that he did have an interest in offering the testimony that he did, and that wasn't tested by defense counsel. One of their many ways that they were ineffective. And the same can be said for Mr. Otis Santayana, who, speaking with our investigator, told us that he was presented with testimony from the state to offer. And his testimony was particularly important because it served to explain the lack of physical evidence, the inconclusive ballistics, and provide a narrative that corroborated Mr. Norman's testimony as well.
How many of the government's trial witnesses testified under oath that your client admitted to them the killing?
I think it was about 9. Again, numbers are bad. I'm really bad with numbers. I'm a lawyer.
No, it was a lot, right? And
However,
some of them, I agree with you, jailhouse snitches, someone else was actually at the killing. That's pretty easy stuff to cross on, and I agree this dentist lawyer didn't. That seems quite inexplicable, almost automatically prejudicial, but then there were others that I didn't see in your brief. You're pointing out that pretrial investigation would have impeached them, and I'm focused particularly on the girlfriend. What did the dentist lawyer not find about her? Because she's the one who said you'll find the guns there, and then they find the guns.
well, I think you're referring to the girlfriend, Stacey Johnson. There were 2 girlfriends, Courtney Hardaway and Susan.
One of them said, he told me you'll find the guns, and then they find the guns.
I think that's referring to Stacey Johnson. Her testimony alone was not sufficient to corroborate Mr. Norman's narrative of the crime and that Mr. Ramey had killed anyone. But more than that, if you review the record, her testimony was actually unreliable. She could not remember several details. She could not describe the alleged guns.
Right, but that wouldn't have to do with the ineffectiveness, right? It's not that there was something found about her. That was
No, that would go to the weight of the evidence unaffected by our argument, which we would posit the evidence that's remaining unaffected by our argument was too weak to convict Mr. Ramey or to sentence him to death. But if I can circle back to the Batson challenge once again, I just wanted to point out a couple more things. Not only did the state fail to reasonably apply clearly established law because of their failure to consider all facts and circumstances, But the state also failed to limit its review of the race-neutral reasons justifying the strike to what was actually stated at the trial court. And here, the prosecution offered two race-neutral reasons. One, if I would have continued questioning, I would have struck her for cause. And that's, on the record, patently implausible. The prosecutor actually told the trial counsel at the time, just before making the strike, that he was not going to strike Ms. Steedham-Scott for cause. And that led trial counsel, in one of many examples of incompetence, to abandon questioning to rehabilitate that juror. Two, the state did not identify any of the reasons listed under Texas law for eliciting for a cause challenge. And three, the record bears this. If the state was interested in a for cause challenge, and if the state was able to strike for cause, it would have done so like it did with the other 6 black veneer members that it struck for cause. The second reason that the state offered is also, I think, implausible. The state said, the questionnaire clearly indicates that she cannot impose the death penalty, referring to Ms. Scott. And a review of her questionnaire does not indicate that she cannot impose the death penalty. It states that she can be fair and open, that she will consider the law and the circumstances. And on voir dire, she said that she would consider the law and the circumstances, that she could see both ways, and that there was no need to change the laws regarding the death penalty. And more importantly, if she was clearly opposed to the death penalty, that was a reason for a cause challenge under Texas law, which suggests that, once again, the state would have actually raised a challenge for cause. And so that reason, both those reasons seem pretextual and also suggest that there was a racial motivation there.
So help me with, I mean, this is a complicated analysis, right? It's just the nature of EDPA. We're talking about whether the last reasoned decision, which I take it as the state habeas court, the application of Miller, L., and Batson was objectively unreasonable. If it was, then we're in de novo review, right? If it's not, what's the next step? Are you saying our court is therefore limited by EDPA to saying, all right, was it an unreasonable application of Batson? It may be wrong, but is it objectively unreasonable? Is that where we would be if we decided that this, in fact, you know, the failure to do the comparative analysis and continue all the other circumstances is not an unreasonable application? We would just, what happens if we disagree with you on that point? Do we just stop there, or do we, what happens to the analysis?
If you disagree with me on that point.
Yeah, does EDPA just stop?
But there is ample reason not to disagree.
No, I understand. I mean, are you, I guess I'm trying to understand, are you also making a factual point? Are you asking for an unreasonable determination of fact? I'm trying to find that in your brief.
Doing both.
Okay. All right.
So that the state court did not consider all facts and circumstances in applying Batson's third step was not only an unreasonable application of clearly established federal law, Batson and Miller, L., but also an unreasonable determination of the facts, because it made the decision that the strike was not racially motivated without considering all the facts that support the strong inference of racial motivation.
Okay.
And so, down to a minute. So I guess I would just wrap up somewhat here and just remind the court that Mr. Ramey is on death row, even though the record indicates his trial was less than fair. I would say far from fair, but less than fair, I think, is a fair statement. And as a reminder, he was represented by trial counsel that repeatedly failed to perform with even minimal competence. They conducted no pretrial or mitigation investigation, instead choosing to rely on the state's open file. They presented a geriatric psychiatrist as a future dangerousness expert, and at the time, Mr. Ramey was 21 years old. And in fact, trial counsel's performance was so concerning that the trial court thrice called ex parte conferences to inquire as to their efforts and investigation. Unsurprisingly, and unfortunately, this means that trial counsel failed to uncover abundant evidence that would have undermined the credibility of the state's key witnesses, in a case where there was no physical or direct evidence. And if this wasn't enough, Mr. Ramey's fate was decided by a constitutionally defective jury, a jury where Black people were systematically excluded from service because of their race. Race was forefront in the state's mind, as evidenced by the disparate questioning that we've discussed, a jury shuffle, the injection of race into the questionnaire and voir dire, and race-neutral reasons proven false by the record, and also the comparison of Cheryl Cheatham Scott to Ms. Laza. These were two of many constitutional errors that infected Mr. Ramey's trial and post-conviction proceedings, which cannot stand. We've demonstrated that Mr. Ramey is entitled to relief under 2254 and respectfully ask this court to reverse the district court's clearly erroneous ruling and issue a writ of habeas corpus. Thank you.
All right, you've saved time for rebuttal, Ms. Burgin.
Thank you.
Thompson?
May it please the court, procedural default resolves both of petitioner's claims. The Batson claim was procedurally defaulted at trial. That's an adequate and independent state law ground requiring denial of habeas relief here.
But the Court of Criminal Appeals did not affirm it on a procedural default ground.
I would disagree with that, Your Honor. The Court of Criminal Appeals didn't issue a reasoned opinion on this issue, so we look through to the last reasoned state court decision. That is the findings of fact and conclusions of law that were recommended to the Court of Criminal Appeals, and that resolved the claim based on procedural default, the failure to make a showing at prong 3 of Batson, more specifically, and in the alternative, rejected the claim on the merits. But Harris tells us that if a state court does something like that, doing it alternatively, the state court is still entitled to have its judgment respected on the procedural default issue because it's AISG. It doesn't matter whether there's also a merits determination. I would submit, Judge Higginson, that when the CCA said, gave a reasoned opinion on the one claim and then said, we've reviewed the rest of the claims and they lack merit, the CCA was not using on the merits, as that term is used as a term of art in the federal habeas context. Saying that something lacks merit in general just means the argument fails. But in any event, even if that claim isn't defaulted.
We've really explored that area in our case law. And when it's a merits denial, I thought it would be precisely this type of syntax that's not sufficient. But do you have a Fifth Circuit case in mind that involved a ruling like the CCA's here that preserved the waiver argument?
Not at hand, Your Honor. The governing Supreme Court precedent certainly recognizes that when there's reason to believe that the state court did not reach the merits, then the procedural default.
Right, but there really isn't reason to believe that because the jury actually hadn't been impaneled yet. It was a strange set of circumstances that pushed it really the moment she was on this, Ms. Dedham Scott was being considered.
Your Honor, if the trial court and the CCA misapplied Texas law, that's not a ground for federal habeas relief.
Right, but I'm saying it supports and buttresses. I think the CCA very perceptively realized that wasn't a valid ruling, hence they made the merits ruling. And I don't see anything in there.
In the recommendation from the trial court recognized that this issue was procedurally defaulted twice over at trial. First, the timing issue. Now, we can debate the meaning of the Texas Code of Criminal Procedure. I would submit to Your Honor that it does not mean what the petitioner says it means. The remedy that's being discussed when that timeline before the panel is seated or before the jury is impaneled refers to getting a new array. Counsel certainly did not request a new array and to restart voir dire. So that Code of Criminal Procedure provision is not implicated here as a matter of Texas law. And of course, an error of Texas law is not ground for federal habeas. The trial court also said that the claim was procedurally waived under Texas law, which amounts to procedural default, because of, as Your Honor discussed earlier with my friend here, the failure to make a showing at prong 3. When the trial court asked Mr. Ramey's attorney whether there was anything else, counsel said, no, Your Honor, and everyone moved on. So, as this court has recognized in Chamberlain and other cases, the trial court did not have a duty to undertake some additional analysis to try to find a Batson violation that hadn't been shown by trial counsel.
Their argument is, and what part of this do you disagree with, that no state court ever has done the facts and circumstances analysis of a Batson third-prong objection. No state court has ever done it. And that alone, it violates clearly established law.
I would disagree with both of those premises, the factual and the legal premise, Your Honor. The factual premise, we do have the state courts reached out to try to resolve this claim on the merits and the alternative. The direct appeal opinion discussed it in a fair amount of detail. It may not have specifically discussed Ms. Laza or the particular comparisons that federal habeas counsel has come up with, but it had the whole record before it, including, as counsel noted, the jury shuffle right before it in the briefing, and considered all those things and concluded that there was no Batson violation.
I guess, maybe you could just help me with your brief. Where in your brief do you ever explore the racial disparate questioning? If we don't see there's a procedural bar, you didn't even dignify that, as far as I can tell.
Your Honor, you're right. Our brief does not include a line-by-line discussion of the disparate questioning, and I'm happy to discuss that now.
It's so difficult. Had they objected and said racially disparate questioning, that's a big issue. And
Right.
You can say, well, it's defaulted, but at least then give it in the brief if we don't agree with the default analysis. Where in your brief do you explore the comparison to Ms. Laza?
Your Honor, we do generally discuss the lack of evidence in the record supporting the Batson challenge.
That's an evasive answer, counsel. Where in your brief do you compare her answers as to hesitancy about death penalty to Ms. Laza's?
Your Honor, I agree that that's not in our brief. I'm sorry. I thought my answer earlier.
Okay, so their biggest arguments supported by case law for why they had some chance to show disparate pretext, indicia of race, their strongest ones are, well, you gave the reason that she's doubtful about the death penalty, but we know that's pretext because if you look at Ms. Laza, she had even more doubts. And the second one is, why did you zero in on the single black juror so much with race-specific questions? And neither of those are dealt with by you in the merits.
Your Honor, I'm happy to discuss those records
All right.
and those issues now.
All right.
Ms. Laza did not evince for the DA the same concern about her ability to impose the death penalty. At ROA 6155 in her questionnaire, she agreed with the following statements. We must have capital punishment for some crimes. Capital punishment is just and necessary, and capital punishment gives the criminal what he deserves. Ms. Stedman Scott did not answer the first two questions, and she disagreed, saying capital punishment does not give the criminal what he deserves. So going into the questioning of these two veneer persons, the DA could have reason to have the concerns with Ms. Stedman Scott and not have those concerns about Ms. Laza. Comparisons of other jurors throughout the record bear that out. When there's something in the questionnaire, when we have the questionnaire, and many of them are not in the record, when there's something in the questionnaire suggesting qualms about the death penalty, concerns about, religious or moral concerns about raising it, then the prosecutor probes those more deeply. You see that with veneer persons of all races. I will also note that if you compare the two voir dires, Ms. Laza, the only question that raised a concern for the district attorney was she noted she might have religious, moral, or personal beliefs that would make it difficult to stand in judgment of another person. She explained that and said, I'm not against capital punishment. I would just hate to have to be the one to do it myself. That's one of the things that the petitioner raises as something that should have made the prosecutor question her more closely. I'll also be happy to discuss the discussion of religion at voir dire.
Well,
I would,
what would help me most would be why such a focus on Miss Dedham-Scott racially?
Your Honor, review of the voir dire transcript generally shows that this was not an isolated incident of focusing on Ms. Stedman-Scott. The brief, of course, focuses on it from the petitioner's standpoint, but I would point the court to Veneerman. I'm so sorry, I'm blanking on his name. Grant Johnson, who was questioned for his discussion went over into the next day. He's a white man. The court talked to him in great detail. The counsel questioned him very probingly on all these same issues.
O.J. Simpson.
Yes, O.J. Simpson, and I would note as a factual matter, Your Honors, the O.J. Simpson trial and the Michael Jackson trial show up at least 6 times in voir dire, not only with African-American veneer persons.
This would have helped me in the brief, but you made your decision.
I apologize, Your Honor. It shows up no less than 6 times, and it's evident from that context that this question was not about her race. It's just a question that this DA occasionally thought was appropriate to ask someone and would give him some insight into their thinking. Stepping back for a moment, unless Your Honor has more specific questions on the merits.
Well, I guess I kind of wanted to step back as well. I mean, as I understand it, what we're doing here in talking in granular detail about this juror versus that juror is sort of a de novo review of the Batson claim, right? I get that. If we get through EDPA, I suppose that's what we would do. Okay, I think that we're on common ground there. The problem is, for the petitioner's perspective, and I want to hear your argument on this, is that first, the Ramey has to establish that there's been an unreasonable application of the holdings of the Supreme Court. Okay. As I understand what counsel opposite said, that unreasonable application lies in the failure of the state habeas court to do a complete facts and circumstances analysis of the Batson claim. Okay, that's best I can tell what's going on here. Our en banc court in Chamberlain held something that sounds quite different, or one might say the opposite of that this clearly established law does not require that, especially when the proponent of the Batson claim doesn't say, look, here's the problem with here's why the strike is not race neutral, and here's why there's discrimination going on, et cetera, et cetera. Is the state's view that Chamberlain shows that there hasn't been an unreasonable application of Miller L. and Batson? Is that the state's argument?
Yes, that's part of our argument.
Okay, well, what's the rest of it?
So the petitioner hasn't identified, well, now an oral argument, petitioner says that Miller L. is part of the clearly established law. So
yeah, but our en banc decision was interpreting Miller L. Am I right?
Correct. So the court has already rejected the reading of Miller L. that the petitioner puts forward here. In Miller L., the court had a holding about some pretty egregious facts and said that that was a Batson violation, even under EDPA review. In Chamberlain, the court explained that an inquiry like that is not required. So Chamberlain is grounds for denial on its own.
I mean, the court...
You said there's something else, and he asked you, what's the something else?
Yeah, what is the something else?
Oh, yes, Your Honor. I just want to specify more generally that it's a bit of a contradiction in terms. More generally, you have to identify the clearly established Supreme Court precedent specifically. Just saying Batson and its progeny or something like the Ash Doctrine doesn't suffice. The court resolved that in Langley and made very clear that the clearly established law needs to be specific. There's no showing of that here. Batson and Miller L. too, which applied the Batson standard, are decided at a high level of generality. And the court explained in Harrington v. Richter that when the Supreme Court precedent is general, there's a wide range of appropriate applications that a state court can make. That's the case here. So there's no D1 ability to overcome the relitigation bar. To overcome at D2, the petitioner needs to say an unreasonable determination of the facts. Here, of course, the state court's findings, which include a finding of no discrimination, those findings are presumed correct, and they must be overcome by clear and convincing evidence. I submit to your honors that that showing is not made here.
In order for this court to do that, do we have to go and do at some level, a comparative juror analysis and consider all the other facts and circumstances in order to figure out whether there's been a D2 violation, assuming that's actually been raised?
Your Honor, the claim that was fairly presented to the state courts did not include these juror analysis comparisons, Ms. Laza, Ms. McGrew, all of those specifics. So the fairly presented claim does not require the court to do that in reviewing what the state court decided. The Lucio opinion explains that the claim is considered the way it was presented to the state court. So this court should not go outside of what was argued and put before the state courts in deciding that. But even if you did, the claim would still fail because, as we've discussed, the comparisons aren't borne out by a review of the voir dire transcripts. They're not borne out by the questionnaires that are in the record, and so on.
And we wouldn't be doing that. As I understand D2, we wouldn't be doing that just on a clean slate.
Correct.
Yeah, I mean, we're not going to sit, well, it would be difficult for me to believe that we would be doing that, but we'll see what happens.
Before you jump away from Batson, did you get a chance to look at, or do you have the district court opinion?
I do, Your Honor.
Do you remember footnote 12 in the last sentence?
So, yes, the district court says that in the federal habeas brief, the petitioner doesn't press that part of the claim.
It doesn't make sense to me.
Yeah, I'm not sure exactly what the district court was referring to.
You're not driving anything from it.
Yeah, I will accept that, that part of the argument is to some degree, presented in this court, and we're not disputing that it's appropriately before the court.
Now, if we jump to, presented in the least favorable way to you, so this is asking you to correct me, it's a dentist who doesn't do much of any pretrial investigation, but he knows from open file that the government's going to rely on jailhouse snitches and someone who's cooperating because he was another person at the killing. And as far as we can tell, he does almost nothing. There's a huge amount of impeachment as to them. My thought would be that the government would, Texas would be saying, we acknowledge that's ineffective performance, but it doesn't matter because there were other witnesses who had no impeachment that are sufficient. But that's not what you're still saying. This fellow was effective in his pretrial investigation of the witnesses. He just doesn't then cross-examine?
Yes, Your Honor. We don't concede IATC.
No, I'm not saying concede Strickland in its entirety. I'm just asking you to explain how you could defend his performance when he knows the cast of characters coming his way, but he doesn't get even basic impeachment.
Well, Your Honor, I don't think the record bears that out.
Okay.
Setting aside the E2 problem of considering all the post hoc declarations, there's a whole string of post hoc declarations from the jailhouse snitches and other states' witnesses saying that, no one talked to me, no one, did these things. There's no deck like that from Mr. Norman, most importantly.
But we could just look at what he did cross them, how he crossed.
Your Honor, the trial lawyer crossed them on all of the things that petitioner says he should have crossed them on. He just didn't do it in exactly the same way. All of these jailhouse snitches, their direct testimony brought out at the very least, what they were in jail for. Someone had an aggravated sexual assault conviction. Someone had a theft conviction. All of these things are crimes of moral turpitude. The jury was well aware of these jailhouse snitches' crimes. So,
but just because the government takes the sting out, they always will, right? That usually you'd expect a defense.
Well, we do see cross on some of those convictions, and to the extent there's no cross, we can't presume that trial counsel was not making a strategic decision. Harrington says that trial counsel has wide latitude to make tactical decisions. There's a broad range of reasonably effective representation. So trial counsel could have taken up a strategy that said, I'm not going to hit these guys with every single conviction because it would be a waste of time, given that the jury is well aware of the circumstances of a jailhouse snitch. Now, the record also does not show the factual premise of Your Honor's question, which is that trial counsel conducted no investigation. That is not in the record. Now, the second chair who submitted a declaration says that he was informed of additional investigation that Dr. Willie, the lead trial counsel, had conducted. And at the ex parte conference that the petitioner's brief refers to, Dr. Willie discussed with the court his defense discovery and investigation that he was doing. Now, I'll note that ex parte conference was an ACCI hearing. The trial court was specifically inquiring of counsel about mitigation and asking counsel, what kind of experts might you need? What kind of motions may you be filing? I would dispute the characterization that that conference was some sort of expression of concern about counsel's investigation. And I'm also unaware of any other ex parte conferences. The brief says several, but only one is identified in the record. So that one is an ACCI hearing. Let's see. If there are no further questions on that part of the Strickland analysis, Your Honor, I would just turn to the prejudice point, because if the court considers this Strickland claim not to be procedurally defaulted, there's no showing of prejudice, either by habeas counsel's performance or by trial counsel's performance. As has been already discussed, the petitioner called his father 2 days after the murders and said, if you were to kill someone, what would you do with the guns? His girlfriend, Stacy Johnson, testified that she drove him to the river where he took some guns that had been hidden underneath his porch and threw them into the water. She described for law enforcement exactly where she remembers the guns falling, and that's exactly where the dive team found the guns. That is damning evidence.
And his only trial response to that was they couldn't lift fingerprints? Is that?
Yes. Yes. So
what about ballistically?
So the ballistics said that the shells and the shots could have come from those guns. It couldn't say definitively whether or not they came from those particular guns. So Ms. Johnson, the girlfriend, then described how the petitioner confessed to the murders. And he told her, I bet you know what this is about. And she says, I was nervous about that. I didn't really know what it was about. But he then confessed to me that the triple homicide was committed by him and that those were the guns.
Remind me, how did what's this defense attorney, the dentist's name? Willie? Anyway, well, how did he cross-examine the
Joseph Willie? Joseph Willie, isn't it?
Williams?
Yes, Dr. Willie.
Dr. Willie? How did Dr. Willie cross?
Dr. Willie has been a litigant in this court for at least 25 years.
Indeed. So
How did Dr. Willie cross-examine
the cross-examination? I think that the second chair cross-examined Ms. Johnson, though I could turn to it and
That's
look to
right.
be sure.
I'll check.
And she doesn't have any convictions or anything to cross her on. They focused on a theory that she had a motive to lie. The idea was the petitioner had broken up with her, and so she must have been lying.
I guess the relevant question here, in opposing counsel's brief, have they suggested there was anything not found as to her because of deficient pretrial investigation?
No, Your Honor. Her testimony would be unaffected by the IATC theory that's presented by the petitioner.
Can you think of any other of the many people that allegedly the defendant confessed to that would be unaffected by if there were poor investigation?
So Mr. Light's testimony, the petitioner's father, is also unaffected. He doesn't have a confession per se, but he testifies to the
statement you quoted.
What would you do with the guns? And I believe Miss Lenormand's girlfriend, no, the other girlfriend, is also unaffected by anything having to do with this impeachment. So,
In terms of cause and prejudice, remind me, at state habeas, the claim out of 22 that related to ineffectiveness was claim 16, right?
I don't recall exactly which number it was, but there were 2 Strickland claims in the habeas petition.
One was the Batson one, primarily that he didn't object, which is its own little, you agree he didn't die.
And then the mitigation Strickland claim.
Right, but in the ineffectiveness, was the state habeas claim as to pre-trial investigation ineffectiveness, or was it mitigation ineffectiveness in Batson? Do you remember?
I believe it was focused on mitigation. I don't believe that it raised pretrial investigation or anything guilt phase. So that's why the claim is procedurally defaulted, and there's no dispute about that.
So we'd have to go through cause and prejudice.
Correct. So to overcome cause and prejudice, the petitioner argues it's Martinez-Trevino, that state habeas counsel was ineffective. I don't think either Strickland prong is reflected in this record for that either. State habeas counsel brought 2 other Strickland claims. Clearly, counsel was aware of the possibility of a Strickland problem at this trial and chose not to bring, we can presume, this particular Strickland claim. Again, counsel has a wide latitude in choosing the strategy for representing his client, and habeas lawyers know you don't dilute strong claims with every single conceivable claim that you could bring.
He diluted a lot. It was 67 pages.
I'm sorry, I couldn't.
22 claims, 67 pages. I'm not sure he was worried about dilution.
I would
anyway.
disagree. A 67-page habeas brief in a capital case in state court is not
Not that big. Yeah, okay.
So Martinez-Trevino does not apply here, but even if it did, there's no showing of prejudice either at the state habeas level or for the same reasons that there's no prejudice at the trial level. Just the inability to bring the claim in state court doesn't satisfy prejudice. There must be a reasonable probability that the result would have been different. So the court should deny that claim. Your Honors, AEDPA imposes significant barriers to relief here, and that's by design. Respect for state court judgments requires that the federal courts tread carefully when considering a habeas petition. That's particularly so where there are unexhausted claims. Here, the Batson claim was procedurally defaulted, so if we were to reach the merits of that claim, there's evidence missing. We don't have the questionnaires for most of the jurors, so we're unable to put everything in context to know why counsel questioned witnesses the way he did. For that reason, the petitioner's juror analysis also fails. He can't make a showing that these jurors were actually comparable as the DA was considering them at the time. As to the Strickland claim, which is also procedurally defaulted, this could have been fleshed out in state court. Other Strickland claims were fleshed out in state court, but the state courts were deprived of the opportunity to consider it. Now, the petitioner argues that his failure to exhaust should be forgiven because a subsequent writ would have been rejected under the abuse of the writ doctrine in Texas court. And that very well may be true, but he should have given the state courts the opportunity to consider something like Martinez-Trevino. And for that reason, the court cannot grant relief on this unexhausted claim. 2254D bars that. So the petitioner needs to take this claim to state court and try to get the state courts to consider it. That would not only give the state courts the opportunity to consider something like Martinez-Trevino for second or successive writs, but it would give the state courts the opportunity to consider the claim on the merits, as the CCA has done in a number of cases where petitioners have asked for something like Martinez-Trevino. In sum, Your Honors, to prevail, the petitioner has to overcome numerous hurdles imposed by AEDPA and, of course, by the substance of his claims. He first has to show that the Batson claim is not procedurally defaulted under Texas law. Then he has to show that there's no room for fair-minded disagreement with regard to the state court's decision on the merits. He has to show by clear and convincing evidence that the state court's factual finding of no discrimination was erroneous. Then he has to prevail at de novo review. As to the Strickland, he has to overcome procedural default. He has to show that habeas counsel was outside the broad range of acceptable trial tactics. That's a most deferential standard to counsel, as Harrington says. And then he has to show prejudice in state habeas. He then has to show the trial counsel was ineffective, and he has to show prejudice there. Then he has to overcome a de novo review, finding ineffective assistance. Again, a most deferential standard. The state submits that the petitioner is not entitled to habeas relief and asks the court to affirm.
All right, thank you, Ms. Thompson. Ms. Burgin, save time for rebuttal.
May it please the court.
The state habeas counsel actually did quite a bit in terms of investigation and interviews and...
Actually, there's nothing on the record showing that state habeas counsel did anything with respect to interviews or investigation. An examination of the state habeas petition would actually show that several of the claims are borrowed from the direct appeal almost verbatim, and the remainder of the claims are based on evidence that is obvious from the record. Texas law requires the state habeas counsel to conduct an extra record investigation, and in this case, Mr. Rogers received a memo from the Texas Defender Services flagging the absence of a mitigation investigation and other investigation and providing an investigation plan for state habeas counsel. Despite this, state habeas counsel's timesheets, records, and file do not reflect any extra record investigation. There are no notes, there's no time shown with investigations, there's no invoices for investigators, there's nothing. And
Well, he spoke to trial counsel, he contacted and visited Mr. Ramey several times, he consulted with Ramey's mother, he investigated a medical examiner issue, examined the records of Ramey's co-defendant. There are several things that are reflected in the record that state habeas counsel did.
Your Honor, I would posit that speaking to Mr. Ramey, his client, and to his client's mother, and to the prior attorney is not an extra record investigation, particularly where the lack of a mitigation investigation is flagged. Mr. Rogers did less than the bare minimum, and there's nothing supporting like the notion that he made a strategic decision not to investigate. And the state cannot fabricate a strategic decision not to investigate. And that is also the same for Dr. Joseph Rutherford Willey, I think the third. His records and timesheets don't show any investigation. There's no invoices. There are no interview notes. And he actually said on the records that he was relying on the state's open file. And that takes me really briefly just to give the court the record sites. There were 3 ex parte conferences, and you can find those at Record on Appeal 585, 594, and 600. But I want to turn to the comparative analysis really quickly.
Well, before you jump back to that, she did describe 3 witnesses that I think maybe correctly your brief hadn't pointed out what it is that would have been impeachment that wasn't found. Do you have a response to that?
Of what it is that would have been impeached. Sure, on the record, Courtney Hardaway, one of the girlfriends, did not actually say that Ramey was a shooter or anything that was inculpatory. As I pointed out at my opening argument, Stacey Johnson was unreliable and inconsistent in her testimony, and Lonnie Light was a telephone call about disposing of some guns. None of those actually connect Mr. Ramey to the commission of capital murder. They don't corroborate Mr. Norman's testimony.
Go ahead to your Batson point.
Okay, but as to, jumping back to Batson and Ms. Laza, the state pointed out, my friend pointed out several questionnaire responses that were different, but didn't point out where Ms. Laza was less strong on the death penalty. For example, in response to questionnaire number 52, which asked, "Do you personally believe that the criminal laws of the United States are too lenient?" Steedham Scott said yes, and Ms. Laza said no. They both responded in response to number 58 that I am neither generally opposed to nor generally in favor of capital punishment. And as to 59, Ms. Laza responded, "There are some kinds of cases in which I know I could not vote for the death penalty even if the law allowed me to, but others in which I would be willing to consider voting for it." Ms. Steedham Scott, by contrast, said she would consider all the penalties provided by law in the facts and circumstances of a particular case. And during Ms. Laza's voir dire, 4 times she said that she couldn't sit and swear that she could impose a death penalty. She would hope that she could make a fair decision. While Ms. Steedham Scott repeatedly said, "I can be fair and open. I can see both sides. I can be fair and open. I will do what the law says."
On disparate racial questioning, the suggestion was if we look at it, there's an individual who was asked more racially targeted question.
There were questions about the O.J. Simpson and Michael Jackson trial that were posed of other jurors and other veneer members. However, the manner in which the questioning was directed at Ms. Steedham Scott was different, and there was also the question of whether she was transferred at work because she was black, which is completely irrelevant to her status and ability to serve as a juror, and plainly a racial question. And that's my time.
Thank you, Ms.
Thank you.
Thank you.
Under submission, we notice that you're court appointed, and we wish to thank you for your service to your client and for your willingness to take the appointment.
Thank you for the opportunity to be heard.
Thank you.
Court is in recess.